I will introduce myself. My name is Tom Thanis. I am the Special Magistrate for the City of St. Pete Beach. I'm an attorney licensed to practice law in the state of Florida. I've been appointed by the city to serve as the Special Magistrate for code enforcement hearings. I'm not an employee of the city. I'm an independent attorney. I do not confer with the City of St. Pete Beach code enforcement officers outside of the hearing process about your cases. Your hearing will be conducted in accordance with Florida law and the city's code of ordinances. The burden of proof is on the city to establish its case. You have a right to respond to the city's case. You'll have an opportunity to testify and present any evidence, including photographs and records. Anyone who will be testifying today will be required to testify under oath. I reserve the right to decide if anything to which you are testifying or any evidence you are presenting is beyond the scope of relevance to your case. My goal is to make sure that I conduct a fair hearing during which everyone is given a chance to present everything you think I need to hear and decide the case. At the end of the case, I will most likely announce my decision. A written decision will follow, and it will be emailed to you within the next day or two. Please understand that I do not have the authority to grant variances or give you permission to do something that the Code of Ordinances does not allow you to do on your property. I'll try to be clear and concise in making my decision. If something about my decision is confusing or unclear, please ask me to clarify. If I find that you violated the Code of Ordinances, I'll most likely give you some time to bring your property back into full compliance, most likely with a specific number of days. I also have the legal authority to impose a fine and administrative costs incurred by the city in filing and pursuing the case. If you fail to pay the fine by the deadline, the city will most likely file a lien against your property, which will cloud title to your property and jeopardize your ability to sell the property or secure a loan on it. When I call your case, please come to the podium and identify yourself and let me know whether you're the owner of the property or related to the property in some other capacity. I will then ask the city code enforcement officer to present the city's case. I'll then ask you to respond and present any information you'd like for me to hear or review. You may ask the code enforcement officer questions, but I'll conduct how the question and answer session will go. At the conclusion of the hearing, I'll announce my decision. You may appeal my decision to the circuit court. Any person who wants to appeal my decision will need a record of the proceedings, which must include a verbatim record of the testimony and evidence upon which the appeal is based. Please understand that the goal of these hearings is not to punish you, but to get compliance if the city is correct in its assessment of your property. The hearing is being video recorded, so you'll need to speak into the microphone at the podium. I'll now ask everyone who will be testifying today to stand and raise your right hand to be sworn in. Do you swear or affirm under oath that the testimony you'll be giving today is the truth? Yes. And I'll show for the record everyone in the audience has stood and been placed under oath. And we'll call the first case. And Mr. McConnell, why don't we call the... yeah,
Mr. Thanis, we actually do have some changes to the agenda.
All right.
We're probably thinking along the same line. So we're going to take care of the cases comply and continue, 3A, 3B.
Okay.
Then we're going to move 4D and 4E to 4A and 4B.
Okay. All right. You want to do 3A first and 3D?
Yeah, 3A and 3B, just because they're status updates,
right,
and then we can get into it.
All right. Case number 2023-0255, Kimberly Ann Jordan, 471st Avenue. Good afternoon, sir.
Good afternoon, Special Magistrate. I'm Louis Cruz, representing the City of St. Pete Beach Code Enforcement. As you know, this is a status hearing. The city has received the signed contract that was asked for by the Special Magistrate at the previous Special Magistrate order. This is a status hearing on the sale of the property where the contract stands for about 60 days. The city is asking for a continuance for the case till October 9th at 1 p.m. I put there, and I apologize for that. I remember you put in for Erica to take care of those cases, so that would be 10 a.m.
All right. I see Ms. Jordan here, right? And we'll indicate you're here. Come on up to the podium. I did see the contract. That was part of the agenda packet, so it looks like you're well on your way to selling your property, right? Any hitches in the process here, or so far everything's moving forward?
So far everything's moving forward. The real estate guy was supposed to come today, but I don't see him.
Okay, so he's the real estate person for the buyer, or your...
Yes, my real estate person.
That real estate person represents you in this transaction. All right.
Yes.
All right, so I'm going to continue the case to October 9th at 10 a.m., not 1 p.m., but 10 in the morning.
Okay.
All right, so it would be nice if you could have the property sold by then. Ideally, it'd be probably good for you and good for the buyer to move forward, so.
Right.
So I'll email, you know what, I don't have your email address because the one I tried using previously, it bounced back. So it was the Corvette something or another?
Yes.
Is that,
Were you able to get my
I was.
I have the new updated one.
all right, did you jot that down on the list?
Yes, I did.
Okay, because that way I can email it to you rather than have it posted on your front door.
Sure.
All right.
Did you put an E after the vet?
I did. Like, you mean, yeah, no, I put it, oh, there's no E after? Okay,
I had a feeling that's what happened.
that's probably what I did.
Well, and just one request, Mr. If anything changes from now until October 9th, if you could just notify the city.
Absolutely.
Thank you, we appreciate that.
All right, good luck.
Thank you.
Hope it works out for you. All right. Next case, 2023-0137, Bradley Olson, 617 72nd Avenue. And Mr. Cruz, your case also?
Yes, sir.
And I saw we're continuing this one also.
Yes.
All right.
Just so, Ryan, can you put the overhead on for me, please? That is an updated photo. They had their silt fence. They put in for the permit that you have asked previously for the special magistrate order that you have submitted. I just wanted to state right here that the property owner has met the special magistrate compliance requirements by applying for a permit and uploading an action plan for demolition of the property. The city is asking for a continuance until September 11th at 1 p.m. for a status hearing on the demolition, if it's not already done at that point. The city is asking for a set date of August 31st for the complete demolition, and would also like to reserve the right to impose fines and administrative costs at a later hearing before the special magistrate.
All right. And I remember Mr. Olson joined us by phone last month. He's not on the line.
I emailed him. He did not correspond back with me to give me assurance that he understood what was being talked about today, but I did email him. If you would like to see it, I can put it on the overhead.
That's fine. The August 31st date, is that the city's date, or is that?
He never answered me during that email. I was asking him, do you have a set date? And he never answered me, so we kind of just.
City's date.
Yeah,
it's the city's
I'll
date,
include that in the order as a deadline for demolition. And I've got a good email address for him, so I'll get that out to him the next day or two.
Perfect.
All right?
Thank you, sir.
Very good, thank you. And the first of the Plaza Beach Motel cases, case number 2022-0772, Plaza Beach Motel LLC, 46th Avenue, St. Pete Beach. And I see Mr. Dewar at the podium. Mr. Dewar, and I note for the record that Ms. Cole is present on behalf of the respondent. And Mr. Dewar, go ahead.
Thank you, Mr. Thanos. Case number 2022-0772, respondent Plaza Beach Motel LLC. As you just mentioned, they are represented by Mr. Robert Saison and counsel. Violation address is 46th Ave. Violation description of property is in violation of sections 1.3, 3.5, 4.8, 23.4, 23.11, 38.4H of the Land Development Code, and 98-123.1 of the Code of Ordinances of the City of St. Pete Beach. Case summary, initial inspection, December 22, 2022. An amended notice, we've sent out several notices. The latest iteration is the amended notice of violation dated 7/11/2023. And the compliance date on that notice would have been July 18, 2023. Notices of hearing dated and posted on the property July 25th, 2023. This is a case where we're going to ask you to make a decision on ensuring that the property does not continue to be utilized the way it is. And so what you're looking at here is the Land Development Code definition for an off-premise parking. If you can note that the parking lot or an off-premise, off-street parking lot that is not on the same property as the principal use, it is designed and intended to serve. And so we will provide evidence where the respondent is allowing vehicles to park on that property. I think he's attempting to use it or utilize it in conjunction with the hotel across the street. The photographs are a true and accurate representation of what was observed on the dates taken. This is the affidavit of posting. And so this is showing you that in the field, it looks like one contiguous lot, and it's not. There are 3 lots, and so we're focused on the highlighted lot in green. That's the 46th Avenue parcel. And that's looking, as I said, from the property appraiser's website. This is a Google overhead of the same parcel, and as you can see, that area shaded in green is the 46th Avenue parcel that is being utilized. That parcel is actually being utilized to access the Gulf Boulevard parcel, which is the next case up. But you can clearly see that that parcel is vacant. And this is what it looked like back in September 2019. That green space that you're looking at is now that. This is the curb that's utilized to access the commercial lot, which we're considering it as a lot that's used for off-street parking, never mind the commercial part of it. But it's the curb that's utilized to access the lots that you just observed. This is an RV back in December when this was first sighted that was stored on the lot. As you can see, there were trees taken down. You can see that from the green space picture that trees were taken down. And there is not just the RV, but the fence that was erected without a permit. This is an overview of that lot from 46th Avenue. Same picture. This is a close-up look at the fence that was erected around the entire 3 lots, or 46th and Gulf. And so the corrective action, the city is requesting approvals and permits should have been sought and obtained prior to the erection of the fence, utilization of the parking lot, and establishment of the use. Vehicles are not to be parked on the lot unless the necessary conditional use permit is acquired, and the fence, we're not going to ask for it to be removed, we're going to ask for it to be permitted. One aspect of the property or the property is partially compliant, meaning that there are no vehicles existing as we speak, as of earlier this afternoon. And we're asking that a fence permit to be applied for by, is August 21st a good date for you, Mr. McCollum?
Yeah, that's fine. I think we said the end of the year, but we'll hear from the applicant. Or not from the applicant, from the property owner. End of the week, yeah.
And so we're asking that a fence permit be obtained by August 21st, and that no vehicles be parked on the lot effective immediately.
Yeah, thank you, Pete. If I may just add a little bit of information, Mr. Thanis, for some clarity. So off-premise parking is something that in this zoning district is allowed through a conditional use permit. I understand the applicant, I believe, has applied for the conditional use permit, but it has not been approved, has not been heard by the commission yet. Therefore, using it as an off-premise parking lot is not appropriate at this time. So once the conditional use permit has been approved, if so, then obviously the property owner would be able to use it that way. So that's the first part. The second part is there's a fence on the property that was erected without a permit. So as you heard from Pete, no cars have been parked there as of today. However, the fence needs to be permitted, and the order just needs to be a standing order until the CUP has been approved. If at all, no cars should be parked on that lot.
The conditional use permit process, that goes before
The city commission.
City Commission. Is there a step before a planning commission or some other?
Not for this one. They've already gone to the TRC, I believe, which is the step before. This specific application does not require the planning board. So I believe it will probably be in front of the commission next month, if not October,
Okay,
for approval.
all right. All right. Ms. Cole. Oop. Actually, ma'am, I'll give you a chance to speak, but I'm going to hear from the respondent's attorney first, and then right after that, unless the city's attorney has some questions that he'd like to have resolved, then I'll certainly give you a chance to tell me what you'd like for me to hear.
Good afternoon, Magistrate Katie Cole with Hill Ward Henderson, representing the property owner, Plaza Beach. Hello, Mr. McConnell. I do have a point of clarification before I get started. The notice that was sent, and I apologize, Matthew, we talked, I know briefly before I had all of this information downloaded. The notice that was sent identifies, for the case that was just presented, identifies this parcel number and the property appraiser shows that parcel to be the skinny parcel that was not subject to the presentation we just saw.
So that's the July 11th amended notice of violation?
Yes.
I think I'm looking at, and is that the one that ends in 1300, but then there's a second one that ends in
In
one on
0013.
13, and that's got the Gulf.
And the 0013 is as to this parcel. So the case that we just saw presented does not appear,
So
match the
it's a
notice.
question of parcel ID number not being accurate on the amended notice. Okay.
because there aren't addresses since
Yeah,
it's
yeah.
vacant.
Just
Generally,
46 Avenue.
and again, with parcel ID numbers, either it's a typo or it is a mistake that was made early in the process and it just has kind of continued on. And I think it was a little fuzzy as far as, I know I'd heard there were 3 separate parcels, but there's only one parcel that accesses 46th, I believe.
There's two.
Two parcels?
correct.
Okay.
Yeah,
Well,
the
and-
third
All right,
parcel.
well, let's do this, let's proceed, and if it looks like the identification of the parcel through parcel ID numbers is a problem, we'll deal with that,
Okay.
all right?
And for the record, parcel ID numbers are not required to be part of the notice of violation, but because they're all listed as 46th Avenue, like, I agree with Mr. Thanis. We can move forward. If there's an issue, then we can handle it at that
Yeah,
point.
and I notice there's no address on either of these, so I'm assuming there's a street address someplace in the assessor's office or.
I believe because it's vacant land, they probably
They
removed
just-
it.
No,
Yeah.
no
No,
street number?
the site address on property appraiser is
All right.
literally 46th Avenue.
All right. I think we're all in the same neighborhood at this point, so let's move forward with the underlying facts and deal with those.
Thank you.
If acceptable to the city, we could use the same evidence for both cases. I brought extra copies, but I don't know how you keep your records. I'm happy to provide extra copies, but
Mr. McConnell, I think the argument that Ms. Cole will be submitting will be applicable to both.
it would be.
Okay.
So I think we've opened up the first hearing. I think let's do this. Let's assume that we can incorporate whatever is said at this hearing into the second one. And if there's a need to address further, additional facts in the second one, we can deal with that then.
Yeah, there's no objection as long as they're the same, essentially, for both cases.
Okay.
Certainly. So with that, I just wanted to address a few things high level first before we talked about what the resolution is in the code. The first thing is this property has been utilized as a parking lot for over 35 years. You can see in the packet that I just provided, the photo that the code enforcement officer provided from 2019 is prior, which showing the impacts of the lot is prior to the current owner's acquisition of the parcel in 2022. So he did acquire the property in May of 2022, and the parcel looked exactly as it did today, minus the fence. We do have a copy of the survey.
Thank you.
I'm sorry.
No problem. I got it.
That that was issued at the time of closing that shows those improvements, the curb cuts, and et cetera, on 46th, similar to as it exists today. If you flip through the evidence packet, sorry, I'm trying to keep track of all my papers here. The front of the packet is a timeline. From 1994 to 2018, the City of St. Pete Beach was the licensee of this property from Duke Energy, Florida Power at the time, and leased, or via license, the part that was shown as, the code enforcement officer showed as a quote-unquote park. That was terminated by the licensor in 2018, and a copy of the termination was provided in your packet for review. The adjacent parcel next to the Drunken Clam was also leased by Progress Energy from for 35 years and was terminated from 1987. You see a letter from Schutz and Bowen terminating that license, referencing back a license agreement to 1987. Both of these were used for storage and parking. And so while the instant case identifies there to be an issue with the current use of the parking, this is the traditional use of the lot. If you flip through the evidence binder, there are photos that are more inclusive than those that were just provided. And this is the current photo, similar to what was just shown by the code enforcement officer. Going back, you see April of 2022, which is the current status of the property, minus the fence. And if you recall, our client purchased the property in May of 2022. October of 2021, similar staging area and parking area. October of 2021, December of 2020. And it's not until you get to January of 2019 that you see the park area that was shown on the photo by code enforcement. So after 2019, beginning in December of 2020, there was already impacts to that lot prior to our client's ownership of the parcel. Based on our research, we didn't see that there were any other code violations for parking or for unpermitted improvements on record with the city, so I don't know if the city attorney knows if at any time prior to the instant case there were any other code violations. The city code obviously has a non-conforming use section. That section allows for the uses to continue if they were properly permitted prior to the enactment of the code requiring a CUP. Parking has existed and storage in this location based on the termination letters that reference the licenses since at least 1987. That predates the current code, which would have required a CUP. Again, there is no way to know whether in 1987 or upon the city's acquisition of the license, either of those were specifically permitted. When our client purchased this, because of the historical use of the property for parking, he made the mistake of presuming that since it had always been parking before, he could continue parking there. And so he sought to immediately make the environment safer by putting the fence around it, acknowledging that that was an unpermitted fence, and his contractor has reached out to the city on Friday and again today attempting to apply for that permit as an after-the-fact permit. And so the applicant or the owner is fine with that. Included in your packet is a copy of the conditional use application that was submitted, as well as correspondence over the course of the past year between staff and the applicant attempting to resolve or attempting to apply for and obtain the CUP associated with the parking. Candidly, because of the historical use of the property, I don't think it's appropriate to cease all parking operations today. We would respectfully ask that the magistrate allows parking to continue unless and until the CUP is approved. Obviously, if the CUP is not approved, that would present a different issue for the magistrate and for the city to deal with at that time. It's anticipated, and we just confirmed with staff, that the CUP application should be heard by the City Commission on September 28th. So we would respectfully request 60 days for resolution of the issue while allowing the parking to continue in that interim, and agreed with the fence permit. I don't know how quickly the city can turn around permits, but certainly the application would be made within the next 2 days, this week, so.
Fence permit, I'm assuming that is an administrative decision, not something that goes to the city commission. I'll look to Mr.
Correct.
McConnell or...
Well, I can't give testimony, but
Yeah, come on up, sir, and if you could identify yourself. And what I'm trying to do is just, I know that there are two separate legal issues here, but I need to deal with the permit issue, or the fence issue, because the city's asking me to enter an order today that would require, actually, the fence to be removed, right? Or you're willing to allow the fence to exist, but no parking during the interim between now and when the CUP decision is made by the commission.
we just need the fence permitted. Correct.
Okay, and sir, your name?
I'm Brandon Barry. I'm a planner with the city. I've been handling Mr. Cezanne's case for the conditional use permit. You're correct. It is an administrative approval for the fence.
Okay, and your name again, sir?
Brandon Barry.
Okay. Okay. And do you have all the information you need then from the applicant?
We're waiting on one more item. We had a staff meeting, which is a required prerequisite for the city commission meeting. We had it back in April. We'd asked for an operations plan based on how he's planning to operate the off-premise use. We haven't received that yet. I did speak to him just before the meeting. I understand that'll be turned in within a week or so, so that will give us everything we need.
All right, thank you.
And not to get confused, that's for this conditional use permit,
Yes.
right? The
Okay.
fence permit, if I'm hearing correctly, they can apply for. It's administrative. I think there's one site inspection, and then they can get an after-the-fact permit.
Permit has been, the application has been filed? No,
It has
that's
not been
August
filed.
21st deadline.
Correct.
The owner attempted to file the application, but the contractor has to file the application. So the
Okay.
contractor, I think, reached out to the city on Friday, didn't connect with the right person. So Mr. Cezanne has been encouraging his contractor to get that resolved today or tomorrow.
Okay.
So we expect the application to be submitted.
So part of the order that I would issue would include a deadline for the application for the permit for the fence, so.
Correct.
And
And I
that will
think
most
this-
likely be the August 21st date, which is a week from today. So that will be,
That's
application comes in, and then it moves through the administrative process. I'm not sure what'll happen as far as the decision. Will you wait to see what happens with the conditional use permit?
No,
No, that can,
it's on its own.
on its own,
Yeah.
okay. All right,
So the owner is fine with this August 21st date. I
Okay.
think the only thing about, and the owner has proceeded with this conditional use permit despite the historic use of the property. The only thing that the owner takes objection to now is the immediate cessation of use of the property based on the historic use.
okay.
So,
Are those guests at the motel that are using the property, or employees, or a combination of both?
a combination of both. It's predominantly employee parking, but overflow parking for guests as needed.
And I saw a couple of RVs on the property. Are those guest RVs, or?
I don't know the answer to that.
Good afternoon, sir. If you could tell us your name, please.
Certainly. Robert Cezanne, 4506 Gulf Boulevard, Plaza Beach Hotel. One of the RVs is my personal RV. That particular RV was vandalized and was in part of a case that the sheriff was still researching, so that was the one that you saw there. It was recently removed, but it sat there from January sometime. We got vandalized in March. It is now gone and will not be coming back. Another one was a guest RV that they got kicked out of Fort DeSoto. Not kicked out, they didn't have a reservation at Fort DeSoto. They came to our hotel, asked if we had enough space for an RV. So it was a guest staying at the hotel, but just parking their vehicle across the street because we didn't have that kind of space at the hotel.
Okay, thank you. And the city's use, maybe, I'm not sure if it's relevant or not, but the city's use, sounds like the city's had a license to use the property for quite some time, going back to the 1980s, is that correct? Is that?
I can't,
To make the distinction, the restaurant adjacent, their license was to the 1980. The city's license, or was 87, the city's license was 1994.
Okay, 87 for the restaurant, and the restaurant was using it for overflow parking also?
Yes.
And then the city's use of the property?
I think there was a combination, Mr. McConnell can speak, of there was some storage and staging area at one point during time. Then there was a park that was created. You saw the
Yeah,
beautiful
so-
picture that
saw
was,
that.
the city then made it into a park until its interest was terminated in February of 2018.
Okay.
So-
And then you can see the improvements to the lot, taking it back, I presume, by Duke, whether it was by the city or Duke, I don't know, in 2019, 2020, to take it back to staging and parking area there.
So, do you mind swearing me in real quick?
Do you swear or affirm to tell the truth?
I do. Thank
Go
you.
ahead, Mr. McConnell.
So the only thing I can speak on, and it's firsthand knowledge, is have no knowledge about the 1994 lease. I mean, if Ms. Cole is saying it's there, I'd have to do a public records request and look at it. I was involved in drafting one that was specific for staging. Right? I'm not going to sit here and say there may not be work trucks there picking up things, but it was never for an off-street parking. It was specific for staging of public works projects. And that lease agreement, I was involved in drafting myself, and that was directly with Duke, which terminated prior to the sale. A question I have, though, is if the applicant's attorney is making a legal non-conforming use, I guess I'm a little curious as to why they were applying for a CUP to begin with.
Well, I think I heard that, and I don't think you're necessarily foregoing the opportunity to raise that issue in the future. Is that correct?
Correct.
And I guess that issue would come to the forefront if the city commission denies the conditional use permit application.
Correct.
At that point, I'm sure that this may end up in court, and I think that issue would be resolved at that level.
The only reason I mention it is because I don't think there's enough evidence on the record to claim right now that it's a legal non-conforming use.
I don't think I want to make that decision.
No,
right
I just
now.
want to be-
I think we'd have to have a lot of evidence for that decision to be made, because I think that really goes back and looking at the history of the land development code when it went into effect, what the uses were prior to that.
Also, if it's been vacated for 6 months. The reason I'm making the distinction is because the question really is very simple. And I think the owner just admitted it. He's parked cars on the lot. You can't park cars on the lot without a CUP, and that's the city's point, is no car should be parked on the lot.
Okay.
RVs, boat trailers, nothing.
Okay, and that I understand.
That's it.
And I think their argument, the owner's argument would be that, that this may have been quote-unquote grandfathered in, and that based on prior use, and if it were going back prior to the LDC coming into effect, it may be a legal non-conforming use of the land.
Yes, and I specifically raised that in light of the city's request to cease use of it immediately,
Yeah.
which I think, as you see with the owner's efforts to obtain a CUP, I don't think he objects to having a approval that complies with today's code, but that doesn't obviate the historical use of this property, how it has constantly been something, whether it was staging, whether it was pre-construction, whether it was parking, off-street parking, off-site parking, off-premise parking.
Yes.
Those all are various uses. We did object to the city's representation in the presentation that it was a beautiful park that my client all of a sudden made into parking, which was not the case. He clearly purchased the property in its current state, and other than the fence, and expected to be able to continue to send
I
that.
saw the surveys dated 2021. Sounds like you closed on the property in 2022.
Correct.
And the park was removed by the prior owner before you closed on the property. Okay.
Yeah, and just Mr. Tan, the reason I'm saying, or the city's argument, is that we're not here to decide legal non-conforming uses, because I think I want to make it clear, the only way that, in my opinion, you can authorize the use of this property until September 28th is if you find it a legal non-conforming use. Right, you can't issue an order allowing the property owner to violate the code. So there's no wiggle room here. It's you either get a CUP or you don't. You're either a legal non-conforming use or you're not, but there's no continued use violating our code until September 28th.
Okay.
I would perhaps disagree with that representation. I think that the magistrate has the capacity to order compliance by a different date, and if the compliance to vacate the property is the same 60 days as compliance of obtaining the conditional use permit, and those dates align, that's within your jurisdiction.
Okay, let's put that issue off to the side for now. The woman in the fourth row, you had your hand up. Come on up, please. And were you here when I swore people in?
I did stand.
You did. Okay, come on up and...
Do I have 3 minutes, or I have as much?
No, you keep going.
Okay.
And if I think you're repeating yourself or becoming argumentative, I'll let you know.
Okay, great,
All right.
thank you. Okay, hi, my name is Amy Auerbach. I live on 46th Avenue. I've lived here since January 2015. I have about 5 points to make, so I'm just going to try to make them as clearly as possible. So one thing I would say is that there's a violation missing, 39.14.b, regarding the fence, that the fence around the property cannot obstruct the view of the property. The blue screen that is currently up is obstructing the view of the property. So if the fence is going to be permitted, I would request that in order to be compliant with that ordinance, the blue screen be removed. I'm also curious about site landscaping ordinances and whether or not they are being complied with. Violations of 22.6 F and G about pervious surfaces and grass. This is not my area of expertise, but other lots in the city, specifically at Mangrove and 75th and 73rd Avenue and Gulf Boulevard, are fully sodded and grassed. The one on 73rd is fenced without a screen. So just wanted to put that out there, that there's potentially some other ordinances that would need to be addressed with the current use of the land. I would also wholesalely reject that this land has historically been used as a parking lot for 35 years. The smallest parcel with the parcel number of 1,300 has been used as a parking lot. It has been graded with white gravel chips for many years, and that was zoned B permit parking for use of the Lido Beach Park, which is on the south side of the sidewalk that divides this, the Plaza Beaches property with the public property that is occupied by the Pinellas County Utilities Building and a true playground, pavilion, and park. The two larger parcels had been grassed prior to the ownership of the Plaza Beach Resort, and so residents did view that as a park and understood it to be zoned for industrial use by Duke Energy, so that the expectation for that land, should it had been used by the prior owner, would have been for, you know, an electrical substation or something like that. So it was never anyone's, in the neighborhood anyway, expectation that that land was a parking lot. So that was news to me today. The other thing I wanted to bring up is there was a presentation at the June 13th, 2023 St. Pete Beach Commission meeting where photographic evidence was provided by residents for multiple violations of these parking ordinances, and I'd like to just run down the ones that were presented during that meeting, and also some other milestones that were shared at that meeting. So, as was stated, the property was purchased by Plaza Beach in May 2022. They immediately started cutting trees, and we know now that July 5th was their after-the-fact permit for that tree trimming. On July 25th, 2022 was the date they finally applied for the conditional use permit. They provided an incomplete permit, but still proceeded to use the land as if the permit had been approved. July 30th, there was cars parked, and these were all images that were presented during that commission meeting that I mentioned. So July 30th, Labor Day weekend, cars were parked in that lot, the two bigger parcels. December 17th, people were living on the property for multiple days. Again, no CUP was granted at that time, and residents reached out to the city staff, and so then the violation was finally issued December 22nd, 2022, with the deadline for compliance being January 15th at that time in that violation issuance. So after December 2022, I think I got that right, the violations continued. January 4th, 2023, people were living on the property, and these were RVs that were not the owner's RVs, they were different RVs. January 26th, there was an RV again. March 4th, there was someone staying overnight in a truck that was parked on the property, the bigger lot that's on 46th Avenue. This violation hearing was originally scheduled for March 13th. And basically, when residents inquired about why the hearing wasn't rescheduled sooner, it was because we were told because they were waiting for the conditional use permit. And then just in terms of timeline, this Memorial Day, there was also cars parked in the lot. And I would just say there was a car parked in the lot when I drove here, going down 46th Avenue. Another thing I just wanted to point out is that the Plaza Beach Motel has 41 rooms and 39 spaces. So trying to say that overflow parking is required by this building seems a bit out of sort of balance with the hotel. So in summary, residents were able to present 8 photographic records of violations at that June 13th commission meeting. So I just wanted to share that information with you, that this respondent is constantly violating, and even if you tell him not to park, we're expecting that he will continue to park, because that's what we're observing as residents in the neighborhood. So we hope that you will be able to come to a decision that, helps the residents have the opportunity for this respondent to go through the proper paces and start complying with ordinances.
Ms. Auerbach, do you live in close proximity to the
Yes, I
lots in
do.
question?
My address is 240 46th Avenue, so I would say I'm like a quarter of a mile, half a mile at the most, east of the property.
And you referenced the City Commission meeting on June 13th a couple of times while you were
Yeah.
testifying. What was the context that the parking lots were before the City Commission at that meeting? Was there a specific agenda
It
item?
wasn't really discussed. I didn't present. It was more like a resident came up and spoke, and then that was it, and no one really addressed it. We were just trying to get it as part of the public record.
That was during the public comment period then? Somebody, yeah.
Correct. Off agenda during that time.
Okay. And then when you mentioned that people were living on the property, and it looks like that issue's not before me, it sounds like that issue's been resolved, but were they living in RVs, or were these people living in tents or
Living in
without
RVs,
homes?
anecdotally, we heard from a resident that they called the hotel, and the caller was told $45 for RV parking, but there was no hookup for the, water or electric on that land.
Okay. Anything else you'd like to add?
That's it. I appreciate the opportunity to be in front of you today.
I'm going to have you stay right there
Okay.
because Mr. McConnell has an opportunity to ask you questions, and
Okay.
Ms. Cole does too.
Okay, great.
So it's not a big cross-examination, but it's
Yep.
called cross-examination by lawyers, but
Great.
they have a right to ask you questions if
Okay,
they
great.
like. They don't have to.
Okay.
Yeah, there's no questions from the city.
Ms.
Okay.
Cole, anything? All right. Ms. Auerbach, if you could leave your email address with Ms. Bodkin?
Ginny's got it on the card.
So when I issue my decision, I'll email the decision to you also.
Okay, I
At least
much
you can see it.
appreciate that.
It's a
Thank-
public record, so feel free to share it with your neighbors.
Okay, thank you. And
You're
I'm
welcome.
I clarified it. I'm on my own today.
Yes.
All right. Mr. Dewar.
Pete Dewar, Code Enforcement Manager for the City of St. Pete Beach, case number 2022-0744.
Wait.
Let me ask, are we, I think we're in agreement. It sounds like the issues are the same for both lots, or are there any issues that are different?
I mean,
The
for the
issue-
record, I don't know how Ms. Cole feels, but we should probably.
I was planning on opening up that
Yeah.
hearing also, and if I was going to invite people to
Okay.
add any information they'd like for me to hear on that piece of property too, because I know there's 2 different properties. The only difference is that looks like one fronts on 46th and the other one fronts on Gulf. Did I simplify that?
Correct, yes, sir.
All right. Before we jump to the next case then, anything to add on the property that has the 46th Avenue address?
Just that the respondent was at a technical review committee meeting, and during that process, I'm sure, I can't be sure of anything, but there was discussion about not utilizing that property until approvals were provided, and that's why we're here. Approvals should have been provided prior to the use of the
So
property.
there was a discussion, were there commitments made by the owner? And again, I'll let the owner and Ms. Cole have an opportunity to tell me what they took away from that meeting, but did the owner commit to not using the property for parking? Because I think I heard today that the owner would like to continue to be able to use the property for parking.
No, we couldn't say that with
Okay.
any degree of certainty.
All right.
I mean, I just want to make sure that we're very laser focused here,
Yes.
right?
Sure.
Need a CUP for off-premise parking. Can't operate a commercial parking lot in the zoning district. There's cars on the lot. It's clear it's being utilized for off-premise parking, and the fence needs a permit.
There you go. Thank you. That summarizes it very well.
Ms. Cole?
Just a couple things to address some of one of Ms. Auerbach's points regarding the charge for things. Because there are only 39 parking spaces for 41 hotel rooms, the Plaza Beach Motel does charge all of its hotel users and guests, if they bring more than one car, a parking fee. So that was not an unusual answer to get that. Secondly, we agree about the fence. I think the only, and the owner has agreed to pursue a conditional use permit. I think the only question is the timeframe of compliance with respect to the immediate use. And because of the historic use, we think the representation that this was vacant land and unused in the past is probably not really the best representation. We would ask for a compliance date that aligns with the issuance of the conditional use. And so within 60 days, that it would either need to have all of the approvals or no cars vacated.
Are there any plans that have been submitted to the city to make improvements to the parking lots?
The conditional use permit has a concept plan. It's included in there. I think Mr. Berry can speak as to the city code has very specific requirements with respect to landscape buffers, wheel stops, the amount of paving versus unpaving, the types of surfaces, and so all of that's being reviewed as part of the technical review with the CUP.
And the entryways then would be improved, so it'll be a hard surface lot then, or will it still be crushed
I'll let you
limestone or shells?
We're still trying to figure this out. The CUP that we're applying for is just going to be a temporary CUP. We actually have plans to redevelop this property altogether. But in the meantime, we're trying to just have parking on that property. To answer Mr. McConnell's question as to why we're even applying for a CUP altogether, it's because the parking that we're parking on right now, show this thing here, we're only parking over here, which was been approved for the last 35 years. This area as well has been approved, the city parking credit. So we have parked right here. This is where the staging area is. This is where I have my RV. I think that is my RV right there. Actually, both my RVs are right there at the moment. So we're really actually now focused. We fenced in the entire area. What I want to make clear to all the residents and to everybody here is that the part that we fenced in is not the entire parcel. It's just a portion of the parcel. My property actually comes all the way out to here, all the way out to here, and it actually goes into this person's house 15 feet. I didn't fence all that, and I could have. All I did was fenced in around the inside of the perimeter here to give the residents the ability to still use the sidewalk. That sidewalk is my private property. I could have been that neighbor and fenced in everything and really kind of closed everybody else, because everybody that lives back here uses the sidewalk to go to Dalton Village. So I want to make sure they utilize this, and everybody living back here as well utilizes the sidewalk to go to the beach. So I could have fenced everything in, completely blocked everybody. I've lived on this island since 1988. I've been a great resident. My family lives here. My family lives here. My parents live here. We just want to be good neighbors. So that's what I did, That's why I've applied for the CUP soon after I bought the property. I bought the property in May, applied for the CUP in July 25th, exactly as mentioned. And we have been working with the city this entire time. Now takes time because architects have to make different changes. Different things have come up. The lady mentioned the fence with the blue mesh on there. Well, we need to have a barrier so that lights don't shine into the residents' houses. So that's part of the CUP. So instead of a normal 6 foot, I went 8 foot just to go above and beyond to make sure that there is no light pollution coming onto the neighboring properties. So if you go onto TripAdvisor, Google, Yelp, anything, you'll see that our hotels are one of the top rated hotels, not just in the city, but in the state of Florida. We actually rate them on the 1% in the country. We're very proud of our properties. We do an extraordinary good job at everything we do. And even with this property here, we're going to do a great job with it as well. And like I said, this is going to be a temporary CUP, and the reason we're applying for this temporary CUP is to be able to utilize everything. Because technically, we feel we have the right to utilize this. We feel we have the right to utilize this. That's just how it's always been. So what we're trying to get the CUP is to allow us to use the rest of the property that we technically, I guess, don't have the right to, and that's why we're applying for the CUP. But we do have, and we feel we've had the right to use those 2 lots since they've always been used as parking. And that's why we're applying for the CUP.
So you mentioned the residential use. The residential use is on the eastern end of the property that you have, is that correct? Looks like there's a sidewalk there east of that.
Yeah, this is the residential area
There.
over here.
Yep.
Over here, and then this side's a park. So the residents live back here, but my property line actually goes into this person's property. So 15 feet on here is my property that goes about to this house, then it boxes in and comes out. If you look at the survey, you'll be able to see that on the
Now I
survey.
see that there's a notch
Yeah,
there or
you'll see
something.
it, yeah. So, and I never fenced that in. I could have fenced it all the way across. I could have fenced it even further. But like I said, I purposely, wanting to be a good neighbor, being a resident of this island for 35 years, want to make sure that we're working with our neighbors and open that sidewalk up for the neighborhood. And then when we do develop something, we of course will continue to come up with some kind of access for the people living over there. So that is part of our master plan.
The parcel you own is an L-shaped parcel. The commercial uses on the northwest corner, are those owned by other?
This corner is a different property owner, yes.
Okay, and then the restaurant?
Different owner as well.
Different owner also.
Oh, yes.
And is the restaurant using any portion of the lot for overflow park? That is the,
So this restaurant here uses the parking here. This restaurant has only a few spots here because this restaurant utilized all this. So all this was utilized by this restaurant. Now that we put a fence here, because now it's private property, they only have the 3 parking spots. They used to have all of this. That's why that lease agreement dates back to 1987 with them using all this as parking. So I'm not doing anything different than that's already been there.
and when your guests come and you have, I heard 41 rooms, 39 spaces on the Gulf side of Gulf, correct?
Right.
On the,
Yep. Directly across, that's my property here.
so if you have no vacancies, all 41 rooms are booked, 41 vehicles appear, at least 2 of the vehicles have to park elsewhere. You have to provide parking elsewhere.
We do. Actually, it's the other way around. It's 39 rooms and 41 spots. So it's 39 rooms and 41 spots. So it's the other way.
The other way.
Yeah, the other way around.
there-
So we have 39
so
spots.
there's-
All of our rooms
If
are.
everybody came in, there'd be 2, you'd be short 2
We'd
parking
be short
spaces.
2, but then where do all of my employees park? I've got 24 employees.
Assumed it was employees.
Yes.
How many, where do you have your guests park and where do you have your employees park? You
So
have 2 lots there, I guess.
right now, there's really somewhat of a schedule. We kind of keep them over here. This is the easiest one because it's the easiest way for them to come across. So we actually haven't even utilized any of this over here. We're mostly utilizing this spot here because there's more than enough parking for what we need just in this here. Now, this has now been cleaned up in the last, I think, 6 months or so. Duke Energy or the city, I'm not sure who finally cleaned that all up and got rid of all the debris. So even though I've owned this since May of 2022, I've never utilized this lot because there was trash there, pilings there, rubble there. So finally, I'm not sure who did it over the summer. This has been cleaned up. So now we can start using this again. Prior to that, we weren't even able to use that because there's so much rubble on that property.
And the underlying zoning on the property, Mr. McConnell or city staff or Ms. Cole?
It's AC Activity Center.
And that permitted uses, like generally speaking?
Generally speaking, and Mr. Berry, correct me if I'm wrong, general commercial uses, retail, hotel, residential is mixed use.
Okay.
Conditional uses are
Because
off-premise parking.
I had heard industrial use previously, or at least that Duke Energy owned it, or probably Duke's predecessor would be my guess.
Florida
going back.
Power owned it, and Duke and Florida Power used it as a staging area, and then I presume they probably, as Mr. McConnell said, licensed it to the city and other contractors for road work, if I had to guess.
They never actually rezoned the property.
Okay.
Yeah, it's never been zoned, I mean,
I was just
to my
curious.
knowledge.
It's never been transportation utility or,
I mean,
No, I don't
at some
believe so.
point, there's going to be a long-term plan, I would imagine, for this property, for something other than just a parking lot. And it sounds like you're not ready to talk about that at this point.
No, no, I would prefer.
Yeah, no, I'm
we
just
don't
trying
wanna
to
open
figure
that.
out, you know, I mean, I guess it's more of a city planning issue more than anything
The
else.
city is aware of what we're looking to.
Okay, all right. Ms. Auerbach has her hand up. You would like to make one more comment? Please come up to the podium, because obviously we are recording this.
Amy Auerbach, 46th Avenue. Just wanted to add a couple of comments regarding the conditional use permit and its contents that might be relevant. Is along with the conditional use permit, there are variances being requested to avoid the requirement to have like walkthroughs. So there's, I'm sorry, I didn't prepare for those ordinance names, but basically the property is required to have like pedestrian access through the property, and they're asking for a variance on that. They're also asking for a variance on landscaping requirements for the conditional use permit of the parking lot. And then also the parking lot intentions have been stated to be a valet parking lot. And so the need of a valet parking lot for hotel guests and employees seems a bit incongruent. Also, 2 people were just killed right at that block in the past few months. So there also is a huge concern. I know it's not really relevant here probably, but just about safety and the nature of having cars coming in and out of there. Because there's Publix, there's the Shell station, and then there's the Drunken Clam and the other commercial property. So I just wanted to add kind of a little bit more context of what was in the conditional use permit in terms of signals of what the owner intends, along with the longer-term future use to develop that property into a hotel.
And I'm assuming the variances would be heard along with the conditional use permit.
If
And
they're
they would
required,
be
the commission can hear both as companion items.
The variances would have to be granted before the conditional use permit goes in, maybe?
I'm not sure, usually questions like that would get answered all at one meeting, but I'm not sure how
Okay.
the city commission wants to act on that.
Okay.
All right.
Thanks. Just wanted to add that.
All right, thank you. All right, my initial reaction is, the first thing I want to do is make sure I keep a level playing field, because I really do think the conditional use permit hearing will be, it'll be a complicated one, there'll be a lot of issues, and I don't want to enter an order that will tilt the balance one way or the other. So my order is going to be more of a status quo order, and I know it's not to the liking of the city, but I am going to impose some conditions in my written order. One will be that there'll be no RVs that'll be maintained on any of the property. So if you have one on there now, I think I heard they're all gone. That'll continue to be the situation, no RVs to be parked on the property. Property will be maintained, and I know there's not much landscaping, at least I didn't see much landscaping, but whatever there is, that must continue to be maintained. The parking of vehicles will be limited to hotel guests and employees and contractors of the hotel, the entity. So you would not be allowed to start renting out space for third parties unaffiliated with the hotel or not doing work at the hotel. The parking would be limited to the one lot that accesses Gulf Boulevard, and that the lot that accesses the 46th would have no parking in it in the interim. Because I think I heard, and again, I'm not sure if I'm pronouncing your name correctly, and actually, I probably won't even do it, but the representative from the LLC indicated that most of the parking can occur on the single lot across the street from the hotel. Mr. Dewar, you want to comment on that part?
I think you're ahead of yourself, because we have not made the Gulf Boulevard presentation, and so you're making a decision hinging on this idea that you can park on Gulf Boulevard. It has to be through 46th Ave.
Access is gained from 46 to get to
Gulf
Gulf
Boulevard.
Boulevard. Okay, all right,
you want me to show the picture?
please. I saw the driveway off of 46, and I think I may have made the mistaken assumption that there was access off of Gulf. There isn't.
There
There's
isn't.
not
Okay.
access off of Gulf.
All right.
currently and historically, any parking has come through here, and the fence goes around the whole thing to allow for that interconnectivity.
Okay. And the blue tarp is on the, is that on,
Oh, the blue tarp is on the fence around the entirety of the property.
okay, all right. Okay. And then I know the city has asked me to require, well, actually on the fence, my order will include permission for the fence to remain in place while the fence permit is being considered by the city staff. And those are my preliminary thoughts. I know we want to hear about the second case, and I'll ask Mr. Dewar to go ahead and start with that, unless you have something about my proposed order, if there are any issues that I have raised that you'd like for me to clarify.
Well, my concern is, how do we prove these are hotel guest contractors and employees? You've now set up a situation where staff would have to go to the property, code enforcement staff would have to go to the property to make this determination as to who these people that are parked on the property are, when the issue is there's no guarantee that an approval will be given by the commission when staff has not even made a decision as to what their recommendation is. So this idea that they can continue to park on the property when no use has been established, I don't know if is the right direction.
Yeah, and my order will include a statement that I'm not making any findings on the non-conforming legal use argument that the respondent would like to preserve for future discussion. So I'll clarify that. And I know Mr. McConnell makes a very strong argument about my order not allowing the property owner to do something that is not allowed by the city code, but I am confronted with that type of situation frequently, where I allow violations to continue on with a specific deadline to get things in compliance. In this case, I'm not ordering compliance because I'm going to let the city commission decide whether the conditional use permit will be issued or not. That'll be the compliance issue. And then I'm sure there'll be a lot of conditions that'll be imposed by the city commission on what the temporary facility will look like and other aspects of this parking lot if they make that decision. So you raise a good point about enforcement, and I guess there's some honor, there's going to be an honor system probably, but I think if the respondent is caught allowing unaffiliated people parking their vehicles there, it'll be an issue that'll be raised before the city commission. It'll be raised before me next time it comes before me, and I'm sure it's something that won't reflect very well on the property owner.
So for clarity, you said hotel guests, contractors, and employees?
Yes. And I'd like to restrict it so we keep it all confined to one area and keep it off of, keep the parking off of 46, though I know that the residential is on the east side of the property, so it's either way, either lot, there's still going to be, it'll be able to be seen, though the blue tarp, I guess, does provide some privacy for the backyards of those residents who are on the east side of this property.
Yeah, one of the issues I have, Mr. Thanis, is it kind of handcuffs us on fines. Because I can't even make fines retroactive at this point with your verbal order, because you're giving them kind of a tool to come into compliance, and the city's position is they're not allowed to have any cards there at all. So like, even if we make the compliance date the 28th, they can come back and say, well, I did exactly what the magistrate told me to do up until that point, so we can't even retroactive have fines. And to Mr. Dewar's point, we don't know if the conditional use permit is going to get approved. It could get continued. I mean, he applied last year, and we still haven't.
That's right. We haven't gotten a violate plan
at a city commission meeting. So those are just my initial concerns.
Ms. Cole?
And what's interesting too, Mr. Thanis, is, again, Pete Dewar on behalf of the city, code enforcement manager. The other issue is, for months, they've been noticed from December through today's date. What was interesting is that there were no vehicles parked on the property today. Why was that, right? It's like almost a game. Let's violate the code up to this point. Today we're going to make a good impression that there are no vehicles on property, just so you can give permission. I mean, it's unfortunate. Thank you.
Okay. Ms. Cole?
There happens to be a car here, as Ms. Auerbach just said, because the bartender is parked there on a daily basis. But that said, with respect to Mr. McConnell's point and fines don't have to be retroactive, first of all. That's obviously within your scope. But I do think it would be fair to say within 60 days, either the CUP is granted or a fine starts ticking if there, and that it would be a repeat violation if there are cars parked there after that 60 days without resolution, presuming that time frame, we think the September 28th time frame, that would allow, I think, Mr. McConnell, the commission meeting date to slip a meeting if it had to as well.
Yeah, so on the fine issue, let's address that. Mr. McConnell raises a good issue. I'll include a provision that indicates that my authority to impose a fine is not restricted by anything that's being entered in the order today. That if the city wants to go back to when the initial notice was issued or the amended notice was issued and ask me to start fining from that date, they'll certainly have that authority to do so. You'll argue against that, and I'll make a decision at that point. I know this is an at-risk temporary solution, I guess, where if the city commission decides that this should not be a parking lot at all and that you never had the authority to do that, and this is headed to court on other issues, that still leaves me the authority to impose a fine for a violation of the city code. Whether that's retroactive or starting from the next date of the hearing, that'll be decided at that point. But obviously, I think, as my first comment was, I'd like to maintain a level playing field so the city commission can make a decision independently of anything I may have decided here. Because really what I'm doing today is I'm not solving the problem today. I'm not issuing anything that is going to sway the commission, nor do I really want to say anything that the commission will say, well, the special magistrate already decided this issue, and our hands are tied. They need to make a decision as to whether that property should be a parking lot going forward. I think I indicated that because of the zoning on the property, at some point long-term, the city may want to see something there, some kind of development, whether it's commercial or hotel style or whatever it may be. That's a long-term planning issue, not a legal issue for me to resolve. I think what's helped me get to this point is the fact that there's been historical use of the property for parking, whether it was by nearby businesses, city, under city auspices. There's always been some type of parking use here for the last, and I don't want to make any findings as far as specific duration because I don't think there's enough evidence in the record to establish it one way or the other. But I think there has been some parking here. I think the respondent understands that he and his staff need to make sure that they don't do anything between now and the decision day for the commission that will make it easy for the commission to say, you're not being a good neighbor. And I think you understand that based on your testimony. So that's going to be the gist of my order for the first case. Second case, I don't sense, are there any other facts that?
I guess I just have a few questions, Mr. Thanis,
Go ahead,
respectfully. I guess number one, are you finding them in violation of this provision?
I am, I am not, no, because I think in order for me to make a finding that includes a violation, I think I would have to have the the non-conforming use issue before me. I think because if this is a legal non-conforming use, then there is no violation.
So, and the only question I have is because you're saying, I'm trying to understand what you're basing the historic use on. Is it the one lease agreement that Ms. Cole supplied? Because there's no pictures, I mean, besides the ones that we've showed you of the restaurant. I mean, all you've heard is testimony, so I'm not even much of it. So I'm just trying to understand the basis behind that finding.
I think I've heard, I saw probably a sketchy picture showing what I thought were vehicles in that parking lot. I think I heard that the restaurant on 46th, the one that's off of Gulf Boulevard, had used the lot for some time. There was a fence that was erected to stop their use of the parking lot that fronts on Gulf. So I sense that there has been, and again, I'm not saying that establishes a precedent that tells the city tells the city commission they have to approve this as a conditional use because there was previous use as a parking facility. I'm not saying that. That's going to be up to them to decide whether that's a relevant factor. But as for, I think if there was some urgency to having the fence removed or changing what I think has been going on those two lots for quite some time, then I would get into that issue. But I sense that, waiting until September 28th for the commission to vet this and make a decision on a long-term basis, I think that probably is the best way for us to go. And so I won't be finding them in violation. I'll be reserving that as I am reserving the issue of fines and costs. Anything else? I will try to put this in writing. I will put it in writing. I'll submit it to everybody that's interested in this. If there is a request for me to reconsider or clarify, you can do it by email. I'm fine. I don't necessarily think unless somebody thinks we need to have another meeting in person or via Zoom, my inclination is just to enter some kind of temporary order that maintains status quo so this issue can get decided by the city commission.
And I think it's the city's position that in order to enter an order limiting the use of the property, you would have to find them in violation. I don't see how you put conditions on someone's use if you're not finding them in violation. So, and I don't want an appealable order before the CUP. So
Yeah,
if Ms. Cole's okay, I think from what I'm hearing, let's just continue this to the October hearing. We'll just continue this to the October hearing, and if they haven't gotten their CUP and they haven't gotten approved, then we'll just rehear this at this point. But I'm a little shaky on the order, respectfully, Mr. Thanis.
Ms. Cole.
I think we are fine with the conditions and the order that you have proposed.
Are you going to sit here and say that you won't appeal it?
This order,
Correct, his verbal one?
well,
I don't think it's appealable anyway, so again, and maybe you can address that, Ms. Cole. I don't sense that you would appeal this order because I've made no findings other than I've entered some kind of interim order. I mean, I think in other areas of the law, conditions are imposed frequently before final decisions are made. I don't want to equate this to a criminal case, but I think there's conditions imposed during bail hearings where no contact orders, no access orders, things like that, without a judge actually making a decision on the case. I think my view is that I don't think I know I'm not ready to make a decision because I really do think the legal nonconforming use issue will come into play at some point in this process. And I think that's an issue that would have to that would require some evidence. So, and I think the conditions I'm imposing are probably more in line to try to protect the area around the property and make sure that the use is not expanded. So,
Okay.
I think I'm hearing Ms. Cole saying no objection to what I've imposed, subject to seeing the final draft.
correct.
And I'll show it as a signed order, but if there's a request for me to revisit it, rehear it, clarify it, somebody will let me know that within a matter of a few days, so we don't have it hanging out there for a while. Okay?
Okay.
All right. Go ahead.
If it's okay with the city, we could just incorporate that
I was
last
about to say,
hearing.
can we just adopt? Yeah, I'm okay if Ms.
Adopt.
Cole's okay. Just adopt all of the arguments from the prior hearing into the other case
Yes.
and the requested order.
Yeah, so that's case number 20220744. That is Gulf Boulevard property owned by Plaza Beach Motel LLC. And we'll show that the arguments and testimony given at the previous hearing on 20220772 are incorporated by reference, and we'll cover the second case.
Okay. And I know we got tied up on the off-premise parking, but just to clarify, they have until October 21st to get the fence permit.
That is part
I
of.
want to make sure.
August 21st.
Thank you. A
August-
week from today.
A week from today to file the application for the fence permit.
Yes.
Right.
Thank you, Beth.
Okay.
Did we discontinue Gulf Boulevard?
Oh, you know what? Before you leave, Ms. Cole, so the October hearing will be heard by Ms. Agello.
I think we're fine for now. We're not continuing it because we just came to an agreement. So if we need to renotice this at some point in the future, then we will.
So I won't be here for the October 9th hearing, and there's another hearing officer for the city, another special magistrate, and I hesitate to hand this off.
I
to
understand.
her because you might end up spending another hour explaining, and she's very bright and understands the law very well, but
We'll work out the dates.
Mr. McConnell and I will work
Yeah.
closely
We'll
together,
work on
both
the dates.
leading
here
up
for
to
the
the
November
CUP
hearing, so if it needs to be continued to November, and if we need something before then, when I'm back, because I'm only gone for 5 days
Okay.
during that period, so.
And just to clarify, for the fence permit, you're going to reserve fines on both?
Yes,
Okay,
reserve fines on both. Okay,
Thank you.
you're welcome.
thank you.
All right. I think we have one more respondent in the audience. Sir, you're in the second row there. Your case is which one?
Adopted the record.
What is,
She agreed to all your presentation.
that is 4A. All right, and if you're ready to,
Whoa.
Mr. Cruz, we'll call that. That's case number 2023-0331, JG Holdings of Pinellas LLC, 8001 Blind Pass Road. And Mr. Cruz.
Thank you, Special Magistrate. I'm Louis Cruz, representing the City of St. Pete Beach Code Enforcement. Just give me 1 second. Kind of have to backtrack a little bit here. All right, we are ready. All right, this is case number 2023-0331. The respondent is JG Holdings of Pinellas LLC. Violation address is 8001 Blind Pass Road. Violation description, the property is in violation of sections 9865-1A, 9866-16, 24, and 4633-4B of the Code of Ordinances of the City of St. Pete Beach. And for the case summary, we have the initial inspection, which was done 5/24/2023. The notice of violation was dated 6/22/2023. The notice of violation compliance date was 7/6/2023. And the notices of hearing dated and posted on the property was 7/14/2023. And just as a true and accurate representation of what I have witnessed, this is the affidavit of posting on the property July 14th at 8001 Blind Pass Road. As you can see here, we have a concrete pad in disrepair. This is where it looks like the trucks come to get their trash, to unload their trash that they have in a commercial holding facility, which is there to the left. And as you can see, the concrete pad is all cracked up over the time of wear and tear. This is also unsightly concrete wall in disrepair that's on the property. As you can see there, it's very discolored. It has not been maintained really with keeping its unsightly look for people passing by in the city street. Also, if you see on the top left part of the concrete wall that has the no parking sign, it is broken there. This was taken May 31st, 2023. Another picture of the concrete wall in the background, very discolored, very unsightly from the city street. Another picture of the wall at the property. Another picture of the concrete wall that is unsightly. And it looks like, I did not get any correspondence from the owner or anybody from the property. This is July 14th. It looks like they tried to repair the concrete wall there. As you can see, it was broken off previously in the other picture. Looks like they tried to fix it. They did not do a great job at that. They did not fill the cracks. It does not look like it was done properly. And just some updated photos of the concrete wall that is unsightly, July 14th. July 14th, the concrete pad. It is in disrepair. This was August 14th today. the concrete pad, and the concrete wall. The corrective action, this property must resurface the concrete pad in disrepair and re-repair the wall, power wash, and paint the concrete wall to prevent deterioration and not create an unsightly condition. The property is not compliant. The recommended action, bring property into compliance by September 1st. If the property is not in compliance by September 1st, then the case will be scheduled to be heard on September 11th, special magistrate hearing for an imposition of fine of $250 per day, retroactive to 7/7 until compliant, plus administrative costs. And that concludes my presentation.
All right. Sir, you want to come up? Good afternoon.
Afternoon. John Grew, I'm the owner of the company that owns the
And
property.
your last name again, sir?
Grew, Grewe.
All right. So you are a member of the LLC
Manager, member.
manager
yeah.
too? Okay.
It's a single member.
You were it.
LLC.
All right. And what would you like for me to hear?
Well, the first I hear of there's a problem is I get a certified letter, I think it was June 26th when I finally got it. And I was going out of town June 28th for the holiday weekend. It's coming up, and I have 10 days to stucco, paint, whatever else. It sounded like I needed to tear the building down, the number of codes I was violating. So I get 10 days over a holiday weekend to cure these problems. And I didn't know it was a problem. The wall's been there for years. Many people from code enforcement and the building department have stood inside that wall, inspected my new parking lot, inspected the building paint. The roof was replaced in 2015. The wall's been there the whole time. Nobody can call me. My number's been the same since I've owned that building. I owned it personally from 2001 until I put it in the LLC a number of years ago. And I get a certified letter stating that, and now here I am. It's like, is this how the city operates now? They can't just, hey, we got a problem with this. What can you do?
So help me with lay of the land. There's a building there that I'm seeing in the pictures, two-story building.
Two-story blue building, that's my apartment building, and it's the parking lot for that building.
Okay, how many units in the apartment building?
18,
Okay, and how many spaces do you have in the?
23.
23. Okay. So there must be some walkway or some door then that gets you from the parking lot to the
There's
building?
the center breezeway at the far back of the parking lot. That's about halfway back in the building. And then the people that park at closer to the sidewalk use the sidewalk to come up to the south entryway.
And the concrete wall is just on the Blind Pass side of the property?
No, it's on the 80th Avenue.
80th Avenue, okay.
Yeah, so it's behind the building that's on Blind Pass Road.
That's the only concrete wall that you have?
Yeah.
Okay, I see another fence separating the parking lot from the building, from the apartment building.
Well, it goes around the entire
The concrete wall does?
parking lot. I used to own a ready-mix concrete company, so I got concrete cheap and I poured a solid wall.
Okay, yeah, you don't see too many concrete walls.
No.
Okay.
Or stamped concrete parking lots and an apartment building.
Mm-hmm. And then the pad, for the waste removal, tell me the story on that.
I didn't know that was an issue. It's not on my property. And, it's access. They roll the dumpster down it they don't pull up in there. They just roll the dumpster into the street.
Okay, and that looks like that's next to the building, because I see some,
That's between the sidewalk and the street. And my property starts the back side of the sidewalk.
okay. Any plans as far as maintaining the,
Well, now that I know it's a
Doing
problem, the apartment building's a work in progress since I've owned it for 20-plus years. I make improvements when I can, and if it's a problem, I fix them. Right now, I'm in the middle of planting over 1,000 Asiatic jasmine plants across the front on Blind Pass Road because I had fountain grass out by the sidewalk, and it was killed by the salt water in the last big storm. So now I'm trying something that's salt resistant and it spreads and it covers. In fact, I was on the premises when that notice was posted on the doorknob of apartment number 9. Literally, I've never met the guy before, but he was 40 feet from me when he posted that. He could have handed it to me, but he didn't ask.
So may I ask a question, Mr. Thanis?
Yes.
You said that when we posted this notice, you were on vacation. When was that?
I went on vacation June 28th and got back July 2nd. I fixed the block wall. What happened was they had taken a roll-off dumpster to the Blind Pass Resort, and their truck hit. So their bumper is, 3 feet high. The bumper of one of their trucks knocked the top off that wall. And I'd been fighting with them, trying to get them to pay for the repair. When I get this letter, I went through and I just took some epoxy to glue the concrete chunks that were left back on there, to show that, oh, I see I have a problem. It's nice to know. I'll fix it. But I'm trying to fight with somebody to get them to pay for it. If I fix it ahead of time myself, I do most of the work
What
myself.
about the driveway or the curb cut? Like some of the issues with the concrete?
The only issue with the concrete's not on my property. I mean, it's just used for the dumpster. I guess I will fix it. I can tear it up. I've got a bobcat and a jackhammer.
So what kind of, I'll ask the city, what kind of maintenance or what improvements would you like to the fence? Because it looks like it's an unpainted piece of concrete.
Yeah, and I don't have any problem, stuccoing it and painting it. I just would like to not have to do it when it's 105 heat index outside.
Mr. Cruz or Mr. Dewar?
Mr. Thanis, Pete Dewar, Code Enforcement Manager, and so in staff's defense, and John, you're aware of this, to be consistent with all of our respondents, we leave a courtesy notice, we send a notice of violation, and then we attach a notice of hearing packet to the property. The point I'm making in saying all that is, at some point, John could have picked up the phone as well to notify staff, hey, what is this about, or to ask questions, but I don't think staff heard from you either.
I didn't hear from staff in the first place.
Yeah, and I don't get involved with that because I understand it's a two-way street.
I find out it's a problem 2 days before I'm leaving on vacation.
Yeah, so we're now here. We know that there's an issue the city has raised, and it's my I have to decide, number one, is there a violation? And number two, what's the remedy if I do find that there's a violation? I'm inclined to say the city's probably right on, the condition of the property of the fence not being where it should be. It looks like.
Absolutely,
Yeah,
I agree.
it needs to be fixed.
I want to stucco it to match the building, the texture, and paint it.
All right. And I heard you say you'd rather not do it while heat index is 105, but, we're not going to wait until November or December to do this work.
Okay.
So tell me how soon you can get the fence issue addressed, and then we'll deal with the
I would say,
Different issue.
60 days.
Respectfully, Mr. Thanis,
Yeah.
respondent said he got back from vacation July 2nd. Right?
Yes.
It's been 6 weeks since then and no work's been done.
Yes.
No, I fixed the wall. And like I said, it's 105. I'm in the middle of another project that
We
I
don't
had
agree
already
to 60
planned.
days
Yeah.
to keep it simple.
Okay. And then the work on the apron, and I just need to be clear on that. It's the apron that provides access to the fenced area where the dumpster is kept. Is that correct?
Yes.
Okay. And to get the dumpster out to the street so the waste hauler can pick it up and dump it, it gets rolled out by hand by the staff of the waste management company.
Yep.
You contract with somebody to do this
Yep,
work.
the city has
So it crosses
contract.
the concrete pad. Is the concrete pad that is owned by Mr. Grew in question here? Is that in bad shape? I'll take Mr. Cruz's view of this first. Go ahead, sir.
Yes, thank you. Special Magistrate Lewis Cruz, representing City of St. Pete Beach Code Enforcement. This is something that I have had, and this isn't me picking out John definitively at all, singling him out. I've had other properties where they've gotten it just resurfaced. You don't have to tear it out with a jackhammer. You don't have to do all that. Just resurface it, just so it's not unsightly. Has a lot of cracks in it, obviously from wear and tear of them wheeling that dumpster out, and obviously them pushing it back in after the trash men are done with their business. I'm just looking for a resurface. I've done it at other properties, and as you know, I'm fairly new to the city. I did not have any contact information that I could find specifically for John. So if it was that easy, I would have reached out. But as you know, it is LLC, so it is multiple units. So I would have not known that he was in the vicinity when I was, posting the property. Unfortunately, I didn't run into him, but I've never met him before. So I wouldn't even if I did see him, I wouldn't even know to go up to him to do that. And again, every notice that is sent out from the courtesy notice, NOV, NOH, has my name signed, first and last, and it also has my number, not only to my supervisor, but to myself, my city supplied cell phone number, but also my office number as well. And I'm readily available and would have been willing to work with him to not get to this point. You just had to reach out. That's all I was looking for.
And the resurfacing part of this, how extensive is the work to be done? Pad on which the dumpster sits and then coming out to the actual curb?
It's actually just that square curb. If I may, I'll go back just to show you more definitively. Just right there, that square coming up right there, and that city right-of-way / his property line, just all that concrete, that's all right there. You can see cracks and all that going through from wear and tear.
So that's on the city side of the sidewalk.
Yeah, it's some of his property, on property appraiser, it's like some of it, and then obviously it's on the, I don't know if there's a contractual agreement through the city of the waste company taking care of them. I am not aware of that.
All right, Mr. Grew?
None of it's on my property.
The pad itself is probably on your property, though,
No,
isn't
it's
it?
not.
It's not?
No.
Where's your property line?
The back side of the sidewalk, 2 feet. My wall is 6 inches from my property line, which is
The wall of the apartment building?
parking lot, which you really
I think
can't
Mr.
tell.
Thanis is referring to the pad in which the dumpsters sit is
The
on your,
pad the dumpster is sitting on?
Yeah.
That's mine.
that's what he was,
And
That's
then-
not getting, you're not asking for that to be replaced, or you are?
No, he's talking about between the sidewalk and
Yeah,
the curb.
where I see some cracks there and that? All right,
What-
all right. So, yeah, it looks like a driveway, but it's not a driveway, because there's no place to go other than just to roll this thing out. And you have some kind of dispute with your waste hauler about handling?
No, different waste hauler.
Yeah,
They dropped a 40-yard roll-off dumpster at my neighbor's,
yeah,
and they used my driveway at that wall, right there, that apron, their truck front bumper knocked the top notch
oh,
off
I can,
that
all
wall
right, all right.
as they were trying to angle it to
Okay.
get in.
Okay.
So I repaired that before I left town, after I got the letter.
Yeah.
And the whole process just irritated me so much that I did not get a phone call before they give me, a list of codes that I'm violating. I just didn't want to talk to anybody.
Yeah.
So I fixed what I could, and I deal with it right now.
Okay.
But like I said, the parking or the ramp for the dumpster, it's got some cracks in it. I was in the ready-mix concrete company. Concrete does 3 things. It gets hard, it turns gray, and it cracks. Okay? It is not a structural thing at all. And it's, I'm sorry, that's kind of nitpicking. And it's not even mine.
Yeah, I'm fine entering an order that would require the fence to be repaired, and then I'll include, if you're going to stucco it and paint it,
Well, I would like to have the time to be able to do that, and like I said, if
yeah,
I can
you
have
asked for
60
60 days,
to
and
do
I know the
that.
city's asking for a shorter period,
Yeah.
and we'll figure that part out. But I just need to make a decision on this apron that's in the public right-of-way, but it's there for your use to get your
Yeah, I mean,
roll-off dumpster
I can
over to the
put
street.
I can put a product from Ardex on there and broom it on. The concrete's still gonna be cracked. The underlying concrete's still gonna be cracked.
Okay. Anything else?
no, I think the city's okay with the property owner working with us on the apron for the dumpster, but the fence for sure needs to be addressed.
Yep. Let's do this. I'll find in favor of the city on the fence issue. I won't impose a fine today. Give you 45 days to get the work done. 45 days from today, so I'll calculate that. My order will include a specific deadline for you to have the stucco work done, the painting done. And is that the entire perimeter of the fence, or what's the city's request on that?
Louis?
Sorry about that. I was just making a note, too. your determination. Louis Cruz representing the City of St. Pete Beach Code Enforcement. Basically, anything that's visible from the city right away, I would like it to be power washed and cleaned up. And if he would like to paint it to match up the building, that would be even better, and also easier to maintain. That would be what I would prefer to be done.
All right. Mr. Grew, power wash and clean.
I can power wash and clean it in that, in a week.
Yeah, and I
Okay.
think I'm hearing a commitment, though, to stucco and paint at least.
Yeah, I would just like
Well,
more time, so I'm, like I said, I'm
How
not.
much?
Like I said, if I have 60 days, get into October when the weather breaks,
You're
for the
gonna-
paint and stucco, I'll clean it this next week.
Yeah, you're really looking at the end of September, so, it's still going to be hot.
Yeah.
It's Florida.
I'm not, I know.
Yeah.
I mean, so yeah, I will pressure wash it, and it'll be nice gray, until I can get it painted. I have to do it anyways, I have to put, before I can seal it up.
On the apron issue, I'll defer a decision on that, let you decide, you and the city have a conversation about that. If you have a product that might smooth that out and provide some kind of short-term fix, I'll let
Yeah.
you decide that. You're in the business, so it makes it a little easier.
I sold that business in
Well,
2005.
you know what
but
you're
I know
talking about.
about it. But like I said,
Yeah.
I have a Bobcat still. I can tear that out in 5 minutes.
Yeah.
But it's
Work with the city on that.
it's kind
Mr.
of
Cruz.
extreme for rolling a dumpster across.
Go ahead, sir.
Special Magistrate, I would just like to add one more thing. The reason I was saying kind of just resurfacing, because I had a previous property, obviously, which has nothing to do with this one.
Yes.
But they resurfaced it, and it did cover the cracks.
Yes.
For him to do what he's saying he will do, that's fine. If he would like to do that, that will cause a permit. Resurfacing for myself is why I say that, because it's not too bad in disrepair. If he resurfaces, he won't need to pull a permit.
Okay.
But that's completely up to
All
the
right,
property.
All right. I'll indicate that Mr. Groove made a commitment to do some kind of an improvement to the apron, and that'll be part of the 45-day deadline. I'll continue this. The problem I have is I won't be here on October 9th. So unless the city wants Ms. Ogello to hear it, the other option is to continue to November 9th, I think it is.
Well, there have been situations, Mr. Thanis, where you include language if needed,
Yes.
right? So you can go ahead and set the October just to put a date.
October 9th.
But if the work's been done and there's no necessity of the property owner being here, then we'll just notify him that the hearing.
Okay, so, yeah, with the October date that you won't be here for, I guess.
Yeah, but there's another attorney who serves
Oh,
as
I understand.
yeah, special magistrate.
So, and like I said, I will pressure wash it, in the next week. But so then you're talking stucco and paint by that meeting?
45
45
days from today is, and that'll be in the order. It'll actually be 45 days, 45 days from today.
Okay.
That's your deadline. We'll calculate that out.
All right. So I'll get it pressure washed, I'll get the stuff to broom onto the apron.
I mean, it's 17 plus 30. You're looking at the end of
End of September.
September.
Yeah,
Yeah,
Okay.
like the 29th probably,
right around there.
29th or 30th.
Okay.
So, okay, and I'll pick an easy date for everybody to remember. Yeah, 29th is a Friday, so it's probably that, so, okay. And then I'm going to reserve a decision on fines. There are administrative fees that the city will most likely, even if I waive the fine, there's an administrative fee that the city is authorized by city code to collect from you for bringing this case.
Well, I know, that's what I'm irritated about, because it's like, it's gonna cost me money
Yeah.
when it could have been a phone
Okay,
call.
well,
Just to be clear, because I've heard it 4 or 5 times now, this isn't our burden, right?
Yeah.
We put you on notice, and you are supposed to keep your property in a certain compliance, Mr. Thanis. I mean, we can't babysit everyone and call all these property owners. Your information's nowhere online, or else we would have, and we left you our information on the notice of hearing.
There's numerous departments have gotten a hold of me, and including Pete has gotten a hold of me for the fire department.
so I think at
My
this,
number's been floating
at this
around here
point,
for 20
at this point, we've communicated a lot of information today. We're all on the same page. The only thing left to do is for me to get the order issued. You left your email address. I'll email it to you, and you'll know what you need to do. And if there's something else I need to decide on this later on, they'll bring it back to me, and we'll decide then.
Okay?
Going forward, you guys know where to find each other.
Yep,
All right.
Thank you.
Thank you, Mr. Grew.
all right.
All right. Let's go to case number 2023-0300-411 80th Avenue, Ronald and Diane Rogi, or Rogge. And for the record, it's 2:39 p.m. Don't see the respondents present today. Mr. Cruz is here on behalf of the city. Mr. Cruz, go ahead.
Thank you, Special Magistrate. Before I get started, I am Louis Cruz with the City of St. Pete Beach Code Enforcement. I did talk to the property owner. He will not be here today. He did inform me like about half an hour, 20 minutes before this hearing that he wasn't going to be able to make it. So I tried to get his email. He didn't have an email to give to me, and it was last minute. So unfortunately, I told him that we would have to go through with the hearing without his, him being present. And I also said that there would be a special magistrate decision that I could also, post on his property, since he, we have done that previously. It's not something I told him that we want to do continuously, but he was not able to give me an email at any capacity to further any information to him.
Yeah, and I'm looking at the pictures. Is that a single-family residence?
Yes.
Okay, and
Yes,
do
sir.
they live there?
Yes.
Okay.
Yes, it appears so. Yes, sir.
Okay. All right, go ahead, sir.
Thank you. This is case number 2023-0300. The respondent is Ronald R. Raji and Diane C. Raji. Violation address is 411 88th Avenue. Violation description: the property is in violation of section 9865-4, 9867C, D, and E, 9866C, 3E, and 4633-12 and 13 of the Code of Ordinances of City of St. Pete Beach. Case summary: my initial inspection was 5/4/2023. Notice of violation was dated 6/1/2023. Notice of violation compliance date was 6/15/2023. Notices of hearing dated and posted on the property was 7/14/2023. And these are true and accurate representation of what I have witnessed. This is the affidavit of posting on the property at 411 88th Avenue on July 14th. And this is where you'll see he had outside storage and junk vessels and abandoned property. This was May 4th, 2023. These are junk and inoperable vehicles, May 24th, 2023. Another shot of the junk and inoperable vehicles. As you can see here, these are not mobile and looks like they haven't been for quite some time. So July 14th, 2023. As you can see here, this looks like to be the blue PT Cruiser, if I'm correct, 11/21 dated. And this looks like that Chevrolet type of van. This was 6/20/2022. As you can see here, he has two trailers, one with a boat being on there. He could not give me any confirmation of those being registered in any capacity. And as you can see, he has outside storage there. I will be able to give you a better view on the next couple slides. Outside storage there to the left, boxes and all different types of materials and debris. As you can see there, those tires that were out front initially being visible from the city street are now kind of pushed into the bush there, but still on the property and still visible depending on what direction you are coming from the city street. And signs and different rakes and stuff that appear to be broken. And these are just some updated photos, August 14, 2023. And as you can see there, the outside storage and the junk vessels / abandoned property have not been rectified. The corrective action: the vehicles must be made operable, registered, or removed, must have proper registration for the boat and trailers, and remove all outside storage so they may not create an unsightly condition. The property is not compliant. Recommended action: bring property into compliance by September 1st. If the property is not in compliance by September 1st, then the case will be scheduled to be heard on the September 11th special magistrate hearing for an imposition of fines for $250 per day, retroactive to 6/16/2023. And that concludes my presentation. Thank you, sir.
Okay, show for the record that, again, no one present on behalf of the respondent. Based on the information submitted by the city, I'll find in favor of the city, find the property to be in violation. I'll accept their recommendation to impose a deadline, and the deadline, I'm sorry, Mr. Cruz, for full compliance?
September 1st.
Yeah, September 1st.
September
Yes.
1st. And that would be to correct and abate all nuisances and bring the property into full compliance by that date. I'll continue the matter to September 11th at 1 p.m., and at that time, I'll make a decision regarding fines to be imposed and administrative costs and whether they'll be retroactive or not.
Thank you, sir.
Yes, sir. Let me ask also on service, we've been emailing the best we can. We don't have an email address for the Rogies, apparently, right?
Yeah, he couldn't give me anything. He even asked his wife, and unfortunately, they don't have anything
All
they
right.
could give to
So,
me.
and I can mail it, and I'm
Okay.
not sure how effective mailing is, whether it's either certified mail or regular mail. If it's certified, sometimes they don't get picked up. They refuse service. So if the city does not have an objection, I'll do what I did with what I did last month with Ms. Jordan, where I didn't have a good email address for her.
Yeah, no, it was incorrect.
If you don't mind, have you serve it, or somebody from the city staff to post it.
No problem.
And I'll still mail it, but I sense you want to get this in their hands as quickly as possible, so I'll include that as part of my order.
Thank you.
No objection?
You said you will also mail it?
I will mail
Yeah,
it.
no objection.
Yeah. Okay, and I think we have the Ritter case. That is case number 2023-0284, 540 77th Avenue, Tara E. Ritter. Show that's 245. No one present on behalf of the respondent. Mr. Cruz, present on behalf of the city. Mr. Cruz.
Thank you, Special Magistrate. Louis Cruz, representing the City of St. Pete Beach Code Enforcement. And we're going to go here. This is case number 2023-0284. The respondent is Tara E. Ritter. Violation address is 540 77th Ave. Violation description. The property is in violation of sections 4633, 2, 3, and 12, 9866, 19, 20, 24, C3, and E of the Code of Ordinances of the City of St. Pete Beach. Case summary. My initial inspection was 5/2/2023. Notice of violation was dated 6/1/2023. Notice of violation compliance date was 6/22/2023. Notices of hearing dated and posted on the property was 7/14/2023. These are a true and accurate representations of what I have witnessed. This is my affidavit of posting on the property at 540 77th Avenue, July 14th, 2023. And as you can see here, this is a substandard property, overgrowth, fence or some type of fence that's in disrepair, and a lot of different agriculture type of stuff that she was using for the plants are kind of broken and misplaced as well. Another shot of the substandard property. Also has a barrel there and many different types of debris. And as you can see, there's the fence I was talking about, a couple different kinds of fences that she has there that are broken and in disrepair. To the left there was initially, this is how the case started. There was a complaint called in, and there was a van that was being worked on leaking oil. As you can see underneath there, there was leaking oil, but this has been rectified. I just wanted to state that that was part of the violation initially. And as you can see here, outside storage of materials and tools and different car parts and things of that nature. There's some more outside storage. More outside storage. This is July 14th, the day of my posting. July 14th. More outside storage. As you can see here, they did clean up some of the vegetation and some of the debris that are there, that were there previously.
While you're on that photo, can you back? Oh, that one's fine too. The red and white thing? What is that?
It looks like it was some type of thing that they put there. It might have been some type of like, what is it called? Like a watchtower, or I forget what what is it? Yeah, like a lighthouse, excuse me, thank you. Some type of lighthouse that they had that looks like it's in disrepair. And obviously, I don't know if they needed a permit for anything such as that, but it is part of the decor that they had for the vegetation there. And they cleaned up some of the vegetation there, cleaned up a lot of the debris. And this was today, August 14th, 11:50 a.m. Still some outside storage there. Fishing rods, different containers, things of that nature.
So while you're on these photos,
Yes.
it looks like there was some effort to clean up the property?
Yes, so that's what I was going to get to towards the end.
All right.
So I'll finish up and I'll kind of dive a little bit more into where we're at, since
ahead.
she's not here to speak on her behalf. The corrective action. Outside storage must be removed along with any unusable or discarded materials or objects. Property is not compliant. The recommended action is bring property into compliance by September 1st. If the property is not in compliance by September 1st, then the case will be scheduled to be heard on the September 11th special magistrate hearing for an imposition of fines for $250 per day, retroactive to 6/23/2023. And that concludes my presentation, but I will highlight some of the things here since she is not here. Ms. Tara Ritter is not here. We have been in communication, open communication. I'm not sure why she isn't here today. She was cleaning up the property, so there continued to be outside storage, and I told her I was not able to close the case. She also was not able to submit or give me any proof that she has her house under sale. It's pending right now. The only verification I have of that I saw and witnessed myself was through Zillow. So she wasn't very good with phones either and wasn't able to email me or text it to me or any of that type of capacity. Unfortunately, I don't know why she's not here today. I told her she was still out of compliance and that she had a date to be set that she told me was going to be August 18th when they were going to finalize the sale. But again, I have no proof of that, and there is continuous, as you've seen there, there was wheelbarrows, containers, because she is moving. She did a lot of cleaning up, but she wasn't here to kind of show the contract was what I was really looking for that she wasn't able to give to me.
Okay. Based on the information submitted by the city, I'll find in favor of the city, find that there were extensive violations that existed previously. Some have been rectified and some parts have not been. So the property still remains in violation in some areas. I'll enter the same order that I'm going to enter for the previous case, where I'll give the respondent until September 1st to bring the property into full compliance, reserve any decision regarding fines and costs until the September 11th hearing at 1 p.m.
Perfect. Thank you, sir.
Now, I have been, Mr. McConnell alluded to it previously, I do add a provision that you'll let a property owner know whether the property owner needs to appear or not. I'll continue doing that. At that point, I want to make sure that you're letting them know that you're not asking for fines, it sounds like in that way. But if you do want to ask for administrative costs, you need to let them know that so they can come in on that if they'd like.
Well, and to the city's point, that language is appropriate if there's some kind of compliance plan or a date prior to a hearing.
Yes.
But generally speaking, yeah, we don't want the burden of having to do that.
Got it, okay. All right, that's fine.
If they're not here, then I'm not inclined to do anything. We're okay with that case.
All right, very good.
Thank you, sir.
Yes, sir.
Did you tell them not to be here?
No, she lives in Colorado and the property is being sold. We're trying to do a lien
Okay.
reduction.
Last one?
Yeah, I believe there's
Lien
a
reduction?
lien reduction at the
That's
end.
case number 2021-0183, 601 77th Avenue, Rebecca and David and Martha Rome. Lien reduction request. Is there some kind of an agreement on the reduction amount?
No.
No.
Is there?
I thought I saw something going from $1,400 and some dollars down to $900 and some dollars.
They asked for 0. Yeah, the property owner.
And the city is agreeing to 900 and,
965-ish.
let
It was on the
let me
agenda, I
confirm
think.
that, 965, yes, sir?
Okay, and then is that inclusive of administrative?
That is inclusive of administrative
of
costs.
fees.
It's $500 fines plus the administrative costs for 465.
Okay. And has the property owner paid the $965?
No.
Not yet. And how much time?
Property is being sold, and so that's why this case is up for hearing. They have put in a request for the final amount
All right, so you're agreeing basically to a $500 reduction.
off of the lien,
Off-
plus the administrative cost. Yes, sir?
So it'll be a total of $965 or $965 plus administrative costs?
Total of $965, which is half of the lien plus $465 for the administrative fines.
Okay, so that'll be inclusive.
Yes, sir?
Okay, very
Thank
good.
you.
I'll enter an order to that effect. And I've got an address. Am I mailing it to? I'm sure they'll find the order because they're going to need it for the,
I'll call the title company.
actually, it's going to be the release of the lien that they're going to be looking for, so.
Yes.
And obviously, I'll probably give them 5 days or 10 days to pay,
Okay. Thank you.
rather than tying it in with the closing.
Yeah.
All right. Anything else on the agenda?
No, sir?
Okay. If not, I'll close the hearing at 2:55.
Very good.
Thank you.
Thank you,